Hi, the purpose of this video is to share tips, 5 tips on how to perform the best you can in a court hearing. And so what I mean by a court hearing, it could be, for example, a final trial, or it could be a temporary orders hearing, any type of hearing that requires you to testify, to, to answer some questions, okay? That can also include questions by your own lawyer if you have one, and the lawyer that represents the other party. And the judge could also ask you a question as well. Now, these tips can apply to many different types of hearings. Number 1, it's taking the oath. You have to raise your right hand. You swear you're telling the truth and nothing but the truth. And you say, and of course you will say, I do. And the purpose of this is because a judge will want to determine if you're telling the truth, if you're what we call credible. Because at the moment the other attorney tries to do something what we call impeach you, to make you say a different answer and they catch you in a lie, then the judge will find you not credible, not telling the truth. And at that point, it'd be very difficult for the judge to change their mind that you're telling the truth for the rest of the hearing. Because if you're not telling the truth at one point, how can the judge determine if you're telling the truth for the rest of the hearing? So it's very important to practice, prepare, but also only tell the truth. Number 2 is about direct examination. This means that if you have a lawyer, that you have an opportunity to answer questions by your own lawyer. But if you're have requested this hearing, then your lawyer will be asking you questions through what we call direct examination. That means your lawyer will be asking you questions in a very simple format. Who, what, when, where, why, and how type of questions. So it's meant to be open-ended questions. That's what we call it, meaning it gives you the opportunity to answer the question the way, of course, that you want it, and not a yes or no answer. So the specific tip is that if your own lawyer asks you a question, like, for example, how was your day? You don't want to give a full story that will take 5 minutes. Just an example, you want to take maybe a 15 to 20 second response time, because the longer your answer will be, it will be harder for everyone involved listening to be able to keep track of everything you're saying. So you need to give your lawyer an opportunity to ask you a follow-up question. Let's say you responded with saying that you had a great day, spent time with family. Then let your lawyer ask you a follow-up question to say, okay, well, what did you do to spend time with your family? Or where did you go with your family? Those type of questions. You don't want to answer the who, what, when, where, why, how questions in one response. You need to help your lawyer to go step by step. We call this storytelling. It's really an opportunity for your lawyer to guide you step by step, so that everyone involved, including the judge and even the opposing lawyer, can understand exactly what you're saying. Another reason to do this is because if there's some information that maybe came out in your testimony that you and your lawyer did not prepare for, then it gives an opportunity for your lawyer to help either correct that or give more context for the judge by asking you another follow-up question. Number 3 is cross-examination. So if this is a situation where you have requested this hearing and this is your motion or this is your final trial, then the other lawyer, the opposing lawyer, has the opportunity to ask you questions, and that's called cross-examination. Their job is to force feed you the answer. Meaning, for example, if the other lawyer wants the judge to believe that you were present at the incident, at the scene of the accident, for example, then they will say that you were there at the accident, on site at the accident on January 1st, weren't you? So they're trying to force you to say a yes or no answer. And they try to stop you, prevent you from providing more information in that answer. Because if you're trying to explain yourself, they might say, that's okay, let me move on to the next question. So your job, if you're facing questions from another lawyer, what you need to do is try to provide more information so that it gives a judge a better understanding of what you're trying to say. Because there could be a situation where you're going to be answering no, but this, or yes, but this. So try to provide more information as quickly as you can right after you say yes or no. And the other lawyer might even start the question by saying that, okay, I only need a yes or no answer for this, but still you need to try to provide more information if you believe it's warranted, if it's required to provide more context. The other tip for cross-examination is that usually the other lawyer has a very specific reason why they're asking these questions. They may only have, like, let's say, limited questions compared to your own lawyer, but the reason is because they want to throw you off. They're not trying to ask you every single question. Overall, during cross-examination, the other lawyer wants to give you a hard time, to trip you up verbally in front of the judge, to mess you up in a way that you probably will get frustrated. Now, your lawyer will have an opportunity to ask you questions again. That's called redirect. Typically, that is very, very limited questions. The reason for the redirect is usually if the other lawyer asks you questions that really trip you up verbally, and it gives you an opportunity for your lawyer to provide, again, more context by asking a very specific question. So if you think you messed up earlier during cross-examination by the other lawyer, hopefully your lawyer will step it up to know what you may have messed up on. Tip number 4, speak loud and clear, especially in these days when it's via Zoom or other type of video conference platform. You want to speak very loud and clear. The same goes if you were in court, because of course the room's larger. You want everyone to hear you. The other reason for this is that if you speak very quietly, even just in general, no one can hear you, right? So, and the second thing is, if you speak more loudly, I mean, not yelling wise, but loudly in general, then everyone will perceive you as being confident, right? Confident in your answers. I know a good amount of my clients, are generally shy people. So we prepare our clients to, when you speak more with your chest up, for example, then you tend to project your voice more forward. Also, this is one of my cases that involves domestic violence, abuse. The other party, the other lawyer, of course, will do definitely their best to throw you off, and they will try to frustrate you and challenge you and be aggressive in the way they ask you questions. So there's even more reason that you need to practice your demeanor, standing, with your back straight up, even if it's remote and we're doing this by Zoom, because the more you're practicing this physical demeanor, your stature, the better it is when you project your voice and you're perceived to sound confident. So please try that. Number 5, and that's maintaining a professional demeanor. Now, this is required throughout the entire hearing, even if it's in person. Again, even if it's in person or if it's by Zoom or some other type of video platform. And the reason is this, because let's say, even if you're not asked a question, but the other lawyer says something and you think that's incorrect, you give like a disgusting look or a very frustrated look, and the judge happens to see you, they could somehow use that against you. So you just want to remain calm, let the judge determine after the hearing what he or she is going to determine, make a ruling on this motion or this trial, because you want the judge to be able to focus. If you're making faces, whether it's on accident or intentional, just don't do it, because the judge will be distracted. You want the judge to focus on the information provided. This can also happen when the other lawyers ask you a question. Again, try your best not to do that, because if anyone else sees, if a judge sees that, then they will probably try to determine if you're telling the truth or not, even more so, pay even more attention to that. Okay, tip number 6 is that you want to be early. Again, even if it's by some kind of video conference platform, even more reason to be early is because you want to make sure technology is working. There's some situations where I've even had the opposing counsel take a long time to log into the system because they just not used to using it for some reason. So even if you're used to using it, there could just be some complication, so many different reasons why there could be a delay. For example, you may have the wrong meeting ID number. So you want to have that saved in your calendar, in your calendar as an event, just saved somewhere so you can access it very easily. And tip number 7 is that you want to keep your cell phone silent. Now, so take it off vibrate. If there's any important phone call, if you're expecting an important phone call, please ask that person in advance to call later in the day after your court hearing, so that you're not distracted by it. And tip number 8 is that you want to, if you have any children, have your children with a babysitter, or I know it's tough during the pandemic, so if you're deciding to have children, stay at home, but please find a way to have them not in the room so you're focused. So there's so many more tips that we can provide and share with you, but at least for this specific video, I wanted to quickly share with you the top 8 tips. Thank you very much and have a great day. And I wish you the best in your court hearing. Friends, thank you for taking the time to watch our channel. Click over here so you can watch our most recent uploads. We'll see you soon.